Ladies and gentlemen, can I welcome you to the fourth and final panel. In the previous panel, we heard about some of the problems facing Christians in Europe from a number of different dimensions, from governmental restrictions, legal restrictions, and in some cases prosecution. We heard about the social dimension, marginalization, pushing faith and Christianity in particular out of the public square. So of course, a session like that leads to the obvious question, what do we do? What's our response? How do we address this? And that's why we have this panel. Our panelists will discuss some of the legal responses to the governmental restrictions on religious liberty, both national and international. Then we will also hear about how churches can help persecuted Christians. There will be some more recommendations in addition to those that Jose Luis Bazan gave, recommendations for the protection of Christian refugees here in Europe. And finally, Gudrun Kugler will talk about political initiatives to address the infringement of religious liberty here in Europe. So without further ado, because we have a full panel of experts, I would like to introduce our first speaker. Robert Clarke serves as legal counsel and director of European advocacy for ADF International at its office here in Vienna. He specializes in religious freedom issues and cases before the European Court of Human Rights, as well as leading efforts across Europe in defense of life, family, and religious freedom. Prior to joining ADF International, Robert Clarke was in-house counsel for the Nursing and Midwifery Council in London, prosecuting cases of medical misconduct. And he qualified as a barrister at 2 Bedford Row in London, specializing in criminal and regulatory law. During his time at ADF International, Rob has been involved in more than 15 cases before Europe's highest human rights court, the European Court of Human Rights, which has jurisdiction over 47 countries. These cases include Mortier versus Belgium, which is challenging Belgium's liberal euthanasia laws, and Tanchev versus Bulgaria, which challenges Bulgaria for distributing educational flyers to citizens, which described the evangelical church as a dangerous sect. Clarke earned his LLB with American law from the University of Nottingham with honors in 2002, having spent 1 year at the University of Virginia School of Law. He completed the bar professional training course at Nottingham Law School, and Clarke completed the ADF Leadership Development Program to become a Blackstone Fellow in 2011. He is qualified as a barrister and is admitted to the bar of England and Wales. Please welcome Mr. Clarke.
Well, thank you for that kind welcome. And thank you very much for remaining with us. I've sat through the day. I've heard a number of very interesting and provocative presentations, well aware that I have to, A, go after them, which is difficult because they were very, very good, and B, difficult because you are now full of food, tea, and possibly the onset of sleep. So I'm going to do my best to try and shift that and keep the tempo up as we go into this final session of the day. We have a choice. We can all be rabbits. What do I mean by that? Well, we can take an approach whereby we say there are all these things that are crushing the freedoms that we would say we cherish, but it's okay because we still have Christ. And so we go down into our holes and we hide there, and then we pop our heads out when we think the coast is clear, and assuming there are no predators, we run across town, we grab our food, and then quick, we go back into our hole. And that's the way that some Christians perhaps would like to see the world today, and they would like to see their faith. The difficulty is that the aggressive secularism that we see, the photos that Ellen showed us earlier, it doesn't respect the sanctity of the Warren. It doesn't respect the sanctity of the church. It has no boundaries. or certainly no boundaries that we might like it to have. So we have a choice. We can take the please leave us alone approach, or we can try and engage. We can try and respond to what's happening. We can make sure we have the right arguments. We can make sure we have the right support, the right alliances, the right networks. And that's what I want to talk about today. I want to talk about the right legal responses to some of the restrictions that we've heard talked about. We've seen restrictions in all kinds of different places, and I want to talk about the responses that we can use in two fora. The first is the legislative or the lawmaking fora. The second is the judicial or the law interpreting fora. So we're going to go through both of these, and I'm going to give you one example in each of them of ways that ADF International has engaged and ways that you may be able to engage. Now, I'm well aware that the room that I'm speaking to today comprises of people in very, very different occupations, people in very, very different stages of life, people with very, very different connections, but you're here because we share a common interest. And I want to challenge you to think, okay, maybe your involvement isn't going to be standing before a court, and that's fine, because maybe your calling is to communicate to others. Or maybe that's not your calling. Maybe your calling is in deep thought, in taking that time away from the front lines to think really hard, as Gudrun talked about already today, about how we respond. What are the very, very best arguments that we can use to say we live in a Europe that is built upon and founded upon Christian values, and they should not be thrown away lightly. So first of all, I want to talk about the lawmaking stage. Paul Coleman and others have already talked about some of the challenges we face. We've heard that fundamental human rights, the right to freedom of religion, the right to freedom of assembly, the right to freedom of expression, that these things are coming under threat. And these are four people that know that very, very well. You've also heard about cardinals and archbishops who've been arrested or at least investigated. It often doesn't go further than that. You might think there's something in it, but often investigated for so-called hate speech. We've had people in the UK dismissed from their jobs because of something they posted on their Facebook wall. And the workplace is probably one of the areas in which we see the everyday impact of governmental restrictions most acutely. So to be clear, I'm talking about legal responses to governmental restrictions, but I make a jump into the workplace because that's where we most often see them. You don't see them quite as often, though they're present in perhaps home life. You don't see them perhaps quite as often in church life, though they are present. But in work life, people feel the obligation, sometimes implicitly, but sometimes also explicitly, to check their faith at the door, to be a secular work person as if that embodies no worldview whatsoever, which of course it does. A diverse society, a pluralistic society, words that the European Court of Human Rights holds up as good, as virtuous, as the kind of societies that we should aspire to. Those are societies which maintain a reasonable balance between different interests, between different groups, between competing priorities. And we need to work out how best to accommodate different beliefs, but we have to be prepared to give intelligent and reasoned answers to that questions. Because the sad irony is that although this aggressive secularism is founded upon some kind of radical view of absolute individual autonomy, these people don't respect Christian autonomy. And we need a response that is intelligent, that is thoughtful, and that takes into account the charges that are perhaps laid against us. That's why I want to introduce to you the concept of reasonable accommodation. And I want to be clear from the start. I don't suggest that this is a legal magic bullet. If it was, I would have been firing it for a very, very long time, and hopefully it would have shot, it would have stuck, and it would have changed the world. By itself, reasonable accommodation doesn't change the world, but it may just change the outcome in cases like these four, which I'm going to talk about in a second, that have come up. And at its heart, it's something very simple. It's a concept borrowed from disability discrimination law, and under disability discrimination law in Europe, in the US, in Canada, and elsewhere, employers are required to make reasonable adjustments. So there is a standard, but to make reasonable adjustments to their work practices. There may be a cost involved, whether it's in employee time off or modifications to a building when you're talking about religious disability discrimination. But employers are required, there's an obligation, it shifts the duty from employee to employer to explain why they cannot accommodate the request that's been made to them. In the US, the standard for that accommodation is the employer has to show that it would cause them undue hardship. And if they can't show that, they have to respond to the request. They have to accede to it. The Canadian model sets an even higher standard. In Canada, where a disability, or in Canada even a religious accommodation is requested, the employer must show that it would be impossible for them to accede or to accommodate the request in order to refuse it. Now, the courts have obviously interpreted those things, and sometimes they've interpreted it in a good way, and sometimes they've interpreted it in a bad way. And I'm going to come to the second stage, the interpretation or the judicial stage later. But for now, having that kind of law on the books that says we recognize the diversity of the society in which we live, and we want to maximize, we want the best possible chance of people getting along with each other, but being able to live in accordance with their convictions and their faith, we want to maximize that opportunity. And that's what the concept of reasonable accommodation tries to do. Rather than saying one size fits all, which it clearly cannot when you get into the niceties of particular employment arrangements, it says, employer, you have to do better. The burden is on you to accommodate this, and you have to show us, if you really can't do it, why it is that you cannot. There were 4 joined cases from the UK. These are the 4 individuals involved that went to the European Court of Human Rights. You're probably familiar with them. Lady in the top left is Nadia Awada. She was a British Airways worker who wanted to wear her cross on the check-in desks, and she was refused, first by British Airways and then by a number of courts in the UK. And the others had similar-ish claims relating to either religious clothing, similar to Mrs. Chaplin in the top right. She was a nurse that wanted to wear a small crucifix at work, and other position-related responsibilities. And the one I want to focus on is Lillian Ladelli. She's in the bottom left. She was a registrar of births, deaths, and marriages in the London borough of Islington, one of the busiest registry offices in the country. She had an exemplary track record over 10 years. She did a good job. She was well liked. She got good appraisals. And then in 2004, when she'd been in this post for quite some time, the UK created same-sex civil partnerships. And she came to the conclusion that, founded on her religious beliefs, she couldn't be someone who would solemnize, who would swear, who would officiate at these ceremonies. And she told her employer, and initially there was no difficulty with that because it was a huge registry office, there were lots of registrars, no one was going to be getting turned away or any of these other concerns that you might have read about in the media. And simply put, when she accepted the job, this wasn't part of her responsibilities. Why not? Because it didn't exist as a legal concept. Ultimately, her employer changed its mind. Her employer forced her out of a job. She took her case to court. She initially won in the UK and then lost, and she took the case to the European Court of Human Rights. A number of organizations intervened, including ADF International, and made arguments for the application of this doctrine of reasonable accommodation. The idea that faith convictions should be accommodated, particularly when we're not seeing any kind of opposing or competing or clash of right. And we weren't. It was quite clear that she could have done her job. She never would have been required to do something that she found morally or conscientiously impossible. And there would have been no disruption to the services. There would have been no interruption to the services. There would have been no additional cost to Islington Borough Council. They'd been doing it for some time. That wasn't accepted at the European Court of Human Rights. They found against her. They made no reference to this concept of reasonable accommodation. And so this is something that I bring before you today, and in whatever avenue you engage, whether it's media, whether it's politics, whether it's lawmaking, whether it's communication, public communications, then think about whether this is something that you can get a handle on and whether it's something you can advocate for. Because we have seen some traction. And I take you now to the UK Supreme Court. Paul made reference to this case earlier. I'm going to go into a tiny bit more detail, but these are the 2 Scottish midwives. People often know them as the Scottish midwives rather than their names. But they're 2 senior Scottish midwives who had been midwives for a very long time. Paul said 50 years of practice between them. And they had been accommodated in their conscientious objection to abortion for many, many years in Scotland. But there were some changes coming, and their employing trust, hospital trust, said, no, you will have to supervise. We accept you don't have to participate, but you have to supervise abortion. And they said, we can't do that in good conscience. We would be the ones that have to step in if there's a problem. We are the ones that people will come to with questions if there's any difficulties or any complications. And quite apart from whether or not this is something within our competence, having not practiced it for a long time because we conscientiously object, that's not something in good faith that we can do. Scotland's highest court agreed. Scotland's highest court said, yes, it is entirely consistent with a right to conscientious objection that that right be interpreted broadly, because it's not supposed to be a very, very narrow right that some people might fall in of and some people maybe, depending on the case, fall outside of. It was intended, generally speaking, to be interpreted broadly. So if you're the person carrying out the abortion, you can avail yourself of it. But if you're the person supervising, you can also avail yourself of it. This went up to the UK Supreme Court, and the UK Supreme Court overruled the highest court in Scotland and said that these ladies were not protected by the right to conscientious objection under British law. However, and this is important, Lady Hale, who's a UK Supreme Court justice, writing for the majority, she said, very sensitively, this, even if not protected by the Conscience Clause, the midwives may still claim that either under the Human Rights Act or under the Equality Act, their employers should have made reasonable adjustments to cater for their religious beliefs. This is a concept that was unknown to British law before this decision of the Supreme Court just under 2 years ago. So we see movement, and this case should have gone back to an employment tribunal. The employment tribunal should have had the opportunity to consider the very thing that Lady Hale seems to be begging for them to consider now, but for various personal reasons the case wasn't continued. But someday soon there is going to be another case, a similar case, because we know how many of these types of cases there are across Europe. Paul's given you plenty of examples, as has Ellen. So we will continue to try and work legislatively to have this incorporated as a concept in law. And when I say legislatively, working with parliamentarians, working with politicians, is important to communicate how it is that we want to try and maximize Christian freedom, yes, but to do so in a way that is intelligent, to do so in a way that is sensitive to the types of arguments that will be leveled against you, like, for example, isn't this just a right for Christians to do whatever they want? Or isn't this going to be something that results in people being denied lawful services or access to goods? And one of the ways we were able to work legislatively in the UK is through a parliamentary inquiry. A number of parliamentarians we work with launched an inquiry asking for submissions on the conscientious objection provisions in British law. So we submitted to the inquiry. We suggested that reasonable accommodation is something that would be one way of maximizing freedom whilst addressing some of those arguments that are often leveled against us. And that was included in the report. The paragraph at the bottom is from the first page of the report. They made 9 recommendations. Recommendation number 9 of the all-party parliamentary pro-life group reporting into freedom of conscience and abortion provision is that consideration be given to the introduction of the principle of reasonable accommodation into legislation in this country. And so there's another avenue that, having pushed and pushed and pushed, we've been able to find an inlet, and we continue to do that. I want to move on to the second topic, which, as I say, is the judicial side of things. So assuming we have a good law in place, how do we make sure it's interpreted in a good way, in the right way? Or how do we prevent it from being interpreted in a bad way? And again, there are lots of roles beyond the traditional legal roles, beyond the traditional lawyer standing in court role when it comes to this. It's not particularly contentious that religious freedom means more than a right to worship. What do I mean by that? Well, the right to worship is normally defined as the right for you to be able to go to church, sing your songs, pray your prayers, and then you go home having put the Bible under the car seats, and then you go to work having hidden your cross away. But the right to worship is not what appears in the Universal Declaration of Human Rights. The right to worship is not what appears in the European Convention on Human Rights. It's not what appears in the International Covenant on Civil and Political Rights. The right to freedom of religion or belief is what appears there, and it's a much more robust and it's a much broader right than that. I want to tell you about a case in which the European Court of Human Rights got that very, very wrong, at least to begin with, and why it's important for us to be vigilant when these foundational but good documents are being interpreted by judicial and lawmaking authorities, whether in our countries at a national level or whether at an international level. And it concerns an Iranian man who was involved in opposition politics in Iran, such as it exists. He found himself twice summoned to the notorious Iranian Revolutionary Court. And on the second summons, he fled to Sweden, where he claimed asylum on political grounds, but also on the grounds that he could be killed as a Christian if sent back to Iran. The Swedish authorities failed to see the danger that as a Christian, he would literally face the death penalty as a male apostate if he were to be returned to Iran. So the Swedish authorities refused his application, and he challenged that first at the lower chamber, or the chamber level of the European Court of Human Rights. Well, what did the chamber say? The chamber returned, frankly, a terrible decision for him, but also for anyone who seeks to rely on Article 9, the foundational cornerstone of religious freedom in these documents. It's been described as such by the court previously. The court found that there is nothing to indicate that the Iranian authorities are aware of his conversion. Consequently, the court considers that the applicant would not face a risk of ill treatment by the Iranian authorities on this ground. The court, it's like bemusing, but went into some discussion as to whether or not the Iranian authorities might have seen the live stream from his church in Sweden, and they might have picked him out as if there's Iranian intelligence officers watching church services in Sweden to see who might crop up. That is totally irrelevant. And that was the argument that ADF International and a number of other organizations made when this case was appealed to the Grand Chamber on the grounds that this is a fundamentally mistaken understanding of the European Convention and a fundamentally mistaken understanding of freedom of religion. Thankfully, we were delighted this year in March when the Grand Chamber returned its decision. It accepted those arguments and it reversed the earlier decision. Oops. Try again. Oops. Can we go back one slide, Alan? I'm going to stop pressing that. I've just got fingers that are far too fat. In light of the risk to Iranian Christian converts, the first thing that they reversed was that there is a real risk of persecution for Christians in Iran. That should not be a news headline. That shouldn't be requiring reversal from the top human rights court in Europe, and yet it did. And the second part was that this particular man was not required to hide his faith. He wasn't required to check his faith at the border post when he returned to Iran. But he should be able to exercise his right to freedom of religion, which doesn't just mean going to church, but it means living in accordance with his faith in his country. Not being able to do that in Iran, he should be able to do it in Sweden. That case, that precedent, has been instrumental in a number of subsequent cases, some of which ADF has been involved in, some of which we've just heard about. It's a precedent from the Grand Chamber of the European Court of Human Rights, A, talking about the situation for Christians in Iran, but B, talking about the importance of that right. And that's why we have to be vigilant. In this law interpreting stage, when we see our courts doing bad things, we have to be ready to speak out on the public front, on the media front, but also on a legal front. So in closing, and we may have some time for questions, but in closing, there are lots of areas in which we can see governmental restrictions on religious freedom, like, for example, in the cases concerning registration of churches or the employment practices of churches, some of which Paul and others have talked about already. And we've had success challenging some of those things at the European Court of Human Rights. And I hope that this has given you some ideas in terms of what can be done, at least some inspiration from a legal perspective in securing and safeguarding rights that exist. This isn't about creating new rights. This is about upholding documents wrought together by our forefathers in the wake of the Second World War, in the wake of some of the worst atrocities that man has committed against man. And my final thought is this. Very often these issues get framed as a clash of rights. They'll say, well, this case is about a clash of rights, and we have to figure out, which right is going to win, and people might have different views on how they arrange that. My advice is don't be too quick to accept that. I think the vast majority of these sorts of cases, whether involving bakers, florists, nurses, midwives, converts, the vast majority of these religious human rights cases do not involve a clash of rights. Some do, I accept that, but the vast majority do not. A clash means two people in front of the court, both of which have human rights claims, and a situation in which not both of them can be met. In most of these cases, the reality is there is a Christian with a human rights claim, and then there's a hypothetical problem that one day there might be a situation whereby said Christian is asked to do something, and maybe said Christian will maybe possibly sometimes have a problem. That is a terrible basis for decision making. That was the case in the Delhi. There was no one making a complaint apart from colleagues who had an issue with the position that she had. That wasn't the case for the Scottish midwives. There was no one making a complaint against them. The hospital simply said that they couldn't work on this basis, the same as we've seen in Sweden. A clinic couldn't possibly work with a midwife who only wants to help babies come into the world. But there's hope. So I say this, reasonable accommodation, Lady Hale, she delivered the judgment in the Scottish midwife's case, but outside of that, she's been delivering a number of speeches. She said this, "I'm not sure that our law has yet found a reasonable accommodation of all of these different strands. The story has just begun." And we've seen similar encouraging things in other places, in other countries, at the European Court of Human Rights. And we hope that the doctrine of reasonable accommodation is something that can help answer some of these questions when the next Lillian Ladeli tragically finds herself embroiled in litigation that she never imagined, that she never wanted, and hauled before the European Court of Human Rights. The reality is that this is not going to go away. We cannot be the rabbits down the hole. People of faith need to come out of their rabbit holes. We need to engage. We need to have good arguments. And we need to be ready to respond, yes, outside of the legal context, but also within the legal context, both legislative and judicial. Thank you.